How to avoid the first-headed monster, disability probate. Oh my. Hi there, elder law care attorney Patrick Kelleher, coming to you from elderlawcare.com. Folks, today's question is how to avoid disability probate and how can I prepare for incapacity? I am going to answer that question today because that is a very important, very common question and sadly very common occurrence in our lives. And from an actuarial standpoint, from a statistical standpoint, most of us will become disabled or incapacitated before we completely check out, right? It's typically like not in the movies. People just don't check out typically like that in real life. Unfortunately, most of us will become incapacitated, disabled for a period of time. Sometimes it's days, weeks, months, or years, because look at the statistical data. They say the average stay in a nursing home is about 3 years or 36 months. We see it every day with our clients as they age in place at our elder law care center. So we see it, incapacity happens to most folks, sadly. And so that's today's question. How do we plan around incapacity? I refer to this as the Big Six disability planning. Big Six disability planning, from my experience, is your sword and shield, your metaphorical sword and shield that will slay that metaphorical first-headed beast, which is probate court. These are the tools that everyone 60 and over should have in their elder law toolbox, okay? And when I say that, you should have these part and parcel as your part of your estate planning portfolio. Number one, durable power of attorney with enhanced elder law powers designed to avoid the stresses and messes of probate court or conservatorships, the formal conservatorship process at the probate court. The solution there, folks, is to make sure you create a comprehensive, durable power of attorney. You're picking your people, your team to step into your shoes to manage your finances, okay? And you're saying to the probate court, thank you, but no thank you. We do not want the economic and emotional headaches of probate court. Number two, comprehensive healthcare proxy to avoid guardianships. A colleague of mine is a very experienced probate attorney. He often gets picked by the probate court to be a conservator, to be a guardian of incapacitated folks who fail to plan. Really important to put these legal instruments, these tools in your elder law toolbox when you're alive and well. So when you're alive and not so well, you're covered, you're protected, and you're not going to probate court for conservatorships and guardianships. Number three, the cousin to the healthcare proxy is what we call the advanced medical directives. That way you can articulate, memorialize all your medical wishes, what you want and what you do not want. I call that the 3 C's because that way you're going to, number one, avoid conflict with medical professionals who are educated and trained to sustain life. Number two, you're going to avoid conflict with whom else when emotions are running high, when there's a loved one ill or incapacitated. That's right, family. The third C is you're going to give your loved one, either your spouse or your child, confidence to make those very difficult end-of-life decisions for you because you're going to have everything memorialized, giving them paint by the numbers instructions on how you would like to be cared for. We call this substituted judgment. They can step into your shoes as your medical surrogate and make the decision you would have made if you were able to communicate, okay? That's number three, advanced medical directives, the cousin to the healthcare proxy. Number four, the Big Six, disability planning. Hippa Authorization, Health Insurance Portability Accountability Act of 1996. Tell me, folks, can you call your spouse's doctor today and say, have my husband or my wife's medical records available? I'm going to come by and pick them up tomorrow. What are they going to tell you? No way, no way. They can't do that, right? So they'll only do that if your significant other or spouse signed a Hippa authorization pre-authorizing, giving you permission to pick up their medical records. Hippa authorization is essential. We typically recommend extended for 2 years, even after the date of passing. That way, if our clients have any uncertainty and they need certainty and closure around the passing of a loved one, with that Hippa authorization, they can still get medical records of their loved one to assess and evaluate to give them certainty and closure in a situation like that. Number 5, living will. Living will is a DNR, a do not resuscitate. and most folks are familiar with that. And number 6 of the big 6 disability planning is the newest tool in the elder law toolbox. We call it a Spoon-Fed Directive. And this was taught to me by a PhD nurse in my elder council organization a number of years ago, who said, you elder law attorneys need to create spoon-fed directives for your aging clients, because that is standard medical protocol they're using in nursing homes and memory care units. Meaning, when you're no longer eating under your own volition, the staff is trained to pick up a spoon and manually spoon feed you. And there was a case out of New York State where an incapacitated nurse later in life with dementia in a nursing home had a healthcare proxy, but it was silent. So they continued to spoon feed her, and they sustained her life by greater than 10 years. And she never wanted that. So number 6, spoon-fed directive, memorialize in writing whether you want to be spoon-fed or not. That way, that'll give your family a legal leg to stand on to advocate for you when that memory care unit or nursing home staff is spoon feeding you. Because from my experience, they'll continue to do that based on their company or corporate policy unless family steps in and asserts themselves. And that spoon-fed directive will give them the legal ammunition and power and authority for them to advocate for you. Folks, there you have it. The big 6 disability planning is the metaphorical sword and shield to slay that metaphorical beast, disability probate, to avoid the economic and emotional headaches of probate courts, such as conservatorships and guardianships. Folks, there you have it. You have the 6 ingredients or tools to put in your elder law toolbox. Now go meet with an estate elder law attorney in your jurisdiction who can help you create these tools, because it'll protect you and your loved ones. If you found this video helpful, please scroll down, post a comment and a question, because a member of our team will get back to you as soon as possible. Please click on the subscribe button, because we will continue to keep you updated on other important elder law topics. If you want a stronger shield to slay that 4-headed beast, strongly recommend pick up a copy of my book on Amazon. Elder law attorney Patrick Kelleher, How to Avoid the 4-Headed Monster of Estate Planning and Elder Law, because you will learn a lot. Folks, thanks for joining us here today at elderlawcare.com.